So I was wondering what the court wanted to do.
I
in terms
don't
of
want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
This hearing kicks off with a seismic shift. Felony reduced to misdemeanor, a survivor dialing in with a raw impact statement, and a plea that lands fast, maybe too fast. Over the next few minutes, we'll unpack why deferred adjudication can feel like relief to some and betrayal to others, what rights are being waived, and which procedural choices here could change both criminal and civil outcomes. Stay tuned.
Judge,
Really?
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of unfair to
See
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can we stand down for a bit?
I'm sorry?
Just stand down to see if she's available to
She
Zoom.
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No? Can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
So,
Oh, hello. Can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault,
Come on.
and then he picks up an indecent.
No. Plea bargain down to a Class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault,
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you.
Shh.
Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I've felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car. And yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, asked that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not going to take it. I'm not taking it, Joe. I'm not doing it. Sorry.
Just
I
because
have
she
more-
spoke first?
Oh, I mean, I don't know. All I know is that
Listen to this. The victim describes ongoing panic attacks, lost income, flashbacks, and a loss of safety that reaches into work and daily life. That testimony doesn't decide guilt, but it absolutely shapes how a judge evaluates a plea. Legally, the victim's claim she wasn't consulted about the plea timeline and lacked access to records raises serious fairness concerns. Informed consent matters. Deferred adjudication means the court withholds a formal conviction so long as the defendant completes conditions. It can be a powerful second chance, but it also requires strict compliance. If the defendant breaks terms, the plea can be revoked and a guilty finding entered, with potentially far worse consequences. For viewers, would you accept a negotiated outcome that guarantees supervision and programming, or insist on a public trial to seek fuller accountability? Drop your
is
take.
that we have a powerful victim impact statement here We have a sexual assault that's being reduced to a misdemeanor, 2-year deferred.
Correct.
Apparently, no one's consulted her regarding this thing, you know,
Mhm.
see whether they,
We have been in extensive communication with her this past.
No, sir. No, sir. I
About the plea
barely
and
spoke
reasons
to you
for
a
it.
couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely, and I'm glad that you're here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, Your Honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's
I
something that
think
you
it's
want to
unfair to
do.
my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm
I
the
was-
victim. I am the victim. How do you even
Please.
speak about? Sorry.
Please,
Yes,
it's
Your
okay.
Honor.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court.
I'm sorry,
In the district court.
in felony district court.
I get it. She feels like, you know, one of the things that we need to take into account, you know, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk and then, or we can set it for trial. It's your decision, Mr.
You do home confinement?
Home confinement? No. That's a gift. No,
Can we stand up?
please.
I just want to do 10 days, just. 10 days. Otherwise he loses his job.
It's better than the current deal from our perspective.
Okay.
Thank you, Judge.
Good.
Okay. Come on.
And also, Judge, the complainant did not finish her impact statement, if she could be allowed to do that.
Yeah. Let me do this first. We'll go through with it and then. So, Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right to have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal. Once you accept this agreement, you can never get out of this. It will continue until you complete this agreement or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this. And if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
He's a U.S. citizen, Judge.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Sorry, let me get back. Okay. I was 2 years of okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results. All things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting, including the police reports, toxology, and stain results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the records, the court records, after being left out of the process. This case was reset.
Pause and parse the deal. 2-year deferred adjudication with required courses, community service, no contact, random testing, and a short custodial term added as a condition. That custody term is a bargaining chip. It's meant to protect the victim and lock in compliance. But remember the trade-offs. By taking the plea, the defendant waives trial rights, cross-examination, and the right to appeal. Deferred adjudication can avoid a conviction on paper if completed, but it also places the defendant under constant judicial supervision. Fail one condition, and the court can impose the underlying sentence. Procedurally, the victim's request for records and a continuance speaks to timing. Rush timelines can limit a survivor's ability to respond and to consider civil options. Bottom line, this resolution guarantees some accountability, but sacrifices the transparency and testing of a trial. Which side of that trade-off do you think serves justice?
This was
here?
reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflects my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. If the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset, and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Yes, thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred. So there's a deferred adjudication. that's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer, you know? I
And
think
so
that's-
trial is not able to go
no, the
forward.
case is done now. It's ended in a deferred adjudication just now, ma'am.
He, okay, and he was previously on the jury adjudication, but what about, I still feel like I'm being silenced with everything that I've been saying.
You know, the only thing I could advise you is go back to the district attorney's office and just start, talking to people there.
To the district attorney's office?
Yes, ma'am.
Judge, our first trial setting was March of last year.
Like,
So, you know,
yeah,
I mean,
I
this
just-
is the first time we're hearing about her asking for anything. And we've
No,
had
I was not,
setting after setting. Excuse me,
I
ma'am.
was not aware.
Excuse me,
I
ma'am.
have all the
Excuse me.
texts of
Can you
the,
finish, please? We've had setting after setting. This is the first time we've heard anything about this from her. So I don't think that's
this
any
is not the
part of-
first time.
Ma'am, let me finish, please.
requested forms before. I have sent
Well, ma'am,
emails
look,
to get these
Mr. Echeverria,
documents and
I
I
don't
was
want to
not
get
granted.
I don't want to get into a big match about what's going on now. The only thing I can say is if you have any kind of disagreements, get back with the office, talk to go to the district attorneys and go talk to them and figure out what else. Like I said, there are other avenues. I can't give you legal advice. I can't tell you what to do from here. Okay?
Okay.
Is that it?
Yes, sir.
Okay. Thank you, ma'am. Okay, so guys, for the record, please announce yourselves. State.
Anna Edie, EADY, for Mr. Wiggins.
Nathaniel Meunier spelled Munier, also for the defense.
So hold on, before you get into anything,
Mhm.
state. You wanted to bring something to the court's attention.
Yes, Judge. So we had received the call that Mr. Wiggins was in violation of the protective order that was in this VPO and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is of course after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
So Judge, I'm going to preface this conversation with, Miss Edie texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect because it's been long enough that the protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken.
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Edie talking to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal
The only
term-
way that we can revoke bone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond, thus no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And
The
not being
only
able.
way, but okay, I understand your plight,
Yes, Judge.
but there are other remedies for you to be able to communicate. Letters, in person, but the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the
But-
problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
this would violate my client's 5th, 6th, 8th, and 14th, off the top of my head, constitutional rights. Right, self-incrimination, because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull him out. You can have private visitation in the rooms
It's
there.
not about me, Judge. It's about felony court. It's a serious issue, but that's the.
Why are
fifth
you
thing.
worried about felony court?
This hearing is a study in the collision between legal strategy and human harm. Deferred adjudication offers rehabilitation and avoids an immediate conviction, but only if the defendant follows the court's blueprint, and the survivor must be given timely access to records and a meaningful voice. Courts can and do use short custodial terms, monitoring, and no-contact orders to protect victims, yet procedural fairness and clear communication remain essential. If you're tracking policy implications, this case highlights why victim notification and record access matter as much as sentencing. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping
You worried
courtroom
about felony
breakdowns.
court?
Because that's why he's in, Judge. Then
Well,
that's
it's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is, and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is.
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry,
But
Judge, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him
So
in another wing.
I was going to talk with the DA, and obviously if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not gonna say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with
I have
constitutional rights.
no other way to prevent him from making phone calls. I have acquiesced to you guys before, and I have admonished him before, please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not going to do it, I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now back in AgSeg.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I have them, I just have to get I have to do the form to get them up with the forms, yeah.
Okay, so let's set up a formal hearing because I don't want, you're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
Trying to think of the last time that I got killed. It could be tomorrow, it'll be a few days. So, I don't know if we want to set it off for next Monday or something like that. I think I should have it by then. This is just the point that I actually connect with spend so quick.
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they
Mr.
can
Wiggins, I'm
in our
going to have you sign an affidavit from today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of ag seg.